Hey, Attorney Brian Parker here with another exciting video. Exciting because we're about to bootstrap, as they say in the business, on an idea, the $24 million consent order against PR. Here's the video I did last week. There's the video, there's a video, and I love doing this. And that video was telling you all about the $24 million consent order against PRA and how you can use it. Well, I don't like talking, I like applying. So you're gonna see how I applied that 24 million consent order against PRA by the CFPB. I used it in a counterclaim, just went driving into this company that was more focused on the amount that my client owed rather than the fact that they could not prove that she owed the debt to them. And that's a common theme that you've heard me say. I'm reaching here for some notes. This week's sponsor is GettyWeb.com. That's GEDIWEB.com. GettyWeb.com. They respect the fact that even though you are really good at what you specialize in, creating and maintaining websites is not in your wheelhouse. I think that means you're good at some stuff, but not at this. So leave it to the IT and AI assisted professionals that have you covered. Website down or was never finished? Question mark. Let GettyWeb.com fix or finish your great ideas. GettyWeb.com lets you focus your energy on what matters to you while they work in the background 24/7 to help your genius flourish. So get up and ready with the helpful IT professionals at Getty. GettyWeb.com, that is. Thank you. Enough with that. I don't do that all the time. I won't bother you with that. Let's get into the meat of the act, as they say in the business, in the comedy business. Okay, so I got this $24 million chip. It's dynamite. I've got this chip that I can use. When do I use it and how do I use it? So the CFPB, as you know from that video I did last week, really came down hard on PRA, and quite frankly, they now demand of their lawsuits more than the law, the FDCPA, and most federal case law requires. And that's because in their assessment, PRA was so flagrant and so offensive, and also ignored their own previous consent order from 2015, that they treated them like repeat offenders and hit them for $24 million. So in your answer, in my answer, in fact, I'll include this on the website, collectionstoppersolutions.com. You know, I always have a video for you, and then I add all these word templates that you can use and apply your state law and facts. And in this case, I'll attach the answer I used. And I had in there the mention of the $24 million judgment against PRA. It's there. I have a counter affidavit, and I'll attach that to the website too. But I really didn't mention it. So my point in telling you that is, do you come out swinging with everything, or do you keep that secret chip in your pocket? So I elected in my counter affidavit to just kind of not use it, but there was plenty there, as always, with the PR case to use. So I sent the attorneys my answer, my counter affidavit, and all the exhibits, and pointing out to them that, hey man, you got nothing. So I said, hey, this is another, and I'll give you the email. Here's Cindy, put up the email one that I sent to the attorneys at PRA, Shazam, and I'll highlight. This is another case with no proof of your client's ownership of the debt. The word debt is nowhere to be found in the lawsuit or bill of sale. The bill of sale says nothing and does not mention the debt or the account number. And I refer it being indicative of securitization. I say there's not an assignment of anything, and there wasn't. And neither is the bill of sale, that only says that Citibank and PRA have a forward flow agreement. Remember, go hard in for the forward flow agreements. A little tip, pro tip. They'll run away from that, they'll fight you, and then they just want to settle the case. You can use it or not, it's up to you. So I point out the fact that they sued in their summons, they had my client in a certain place, which she's never lived at. It turned out to be her ex-husband's address, who I don't think she was married to him for a decade. However, and so the summons they filed with the court and the process server served was her ex-husband. So now her ex-husband knows everything that's going on. And I point out, you shared everything about her being pursued by a debt collector with the ex-husband. Thanks for that. Which is a violation of the FDCPA. The weird thing is, you can see in my answer on the template and in my counterclaim I'm going to show you, they had her real address in their own notes that they attached. So they had her real address where she lived, but they put her ex-husband, who she's never lived with in 10 years, at that location and served him and notified her that she's being sued. A direct violation of the FDCPA. I point out in the first, and this is an email to them trying to settle the case. So I always try to get the case settled before I go into counterclaim. So the counterclaim is my stick. Here's my carrot, which is this email saying, here's what you did wrong, willing to work with you. I'm going to give you 7 days. I wrote this on the 4th of July, I think, and I gave until July 7th to settle. That's my modus operandi. You can do it. I've talked to you in a 4-part series on my membership video, how to settle lawsuits, how to make, not threats, but how to have hard deadlines. If you go to my membership website, you'll see, actually there's a 4.5-part series called the ABCs of Debt Collection Self-Defense. And every aspect of the process of settling cases, fighting cases, handling summary dispositions, going to court, it's all in that 5-part series. Put up the video, Cindy. Keep those, it's like 4 or 5 videos. Keep them up there because they say it better than I do. There it is, there it is, there it is, zoom. So I tell them that the complaint references an affidavit, that's their lawsuit, that doesn't exist. It's not attached. The pleadings reference only an account owed rather than a debt, and there's no contract. So I go through the litany of issues. I do that with every email. So you've got the email that I send, and now normally within certain guidelines, they're just going to come back and say, okay, we'll give you a mutual walkaway. A lot of defense firms now just go, we'll do our usual mutual. Everybody shortens everything. So it used to be, we're going to do this, we're going to do it. Now it goes, we'll just do the usual mutual. So they write me back, the first attorney, Brian, oh, well, let's put it up. Shazam number 2, Cindy. I had a chance to speak to my client with this one. I appreciate your patience. However, after speaking to my client, we can't agree to a mutual on this one. See, everybody cuts it all down. If your client is in position to try to resolve, I will get you the best number I can and set up payments. But at this time, we can't agree to a mutual walkaway. Hopefully, we can still resolve. Let me know how you want to proceed. Have a nice weekend. It's a nice guy. There's no problem. So I write back, Mike, good morning. I've taken your account of my client. We want a mutual walkaway, and this is open through the close of business today. You do that, and as I said in my ABCs of collection defense, I think it's the first video, when you are settling, you have to set hard deadlines. Number one, if, for example, you're answering the lawsuit, you got 21 days to answer, you set a hard deadline in your head and go, I want this worked out by the 15th, and you engage them. And if it doesn't settle on the 15th, get that answer filed because they'll keep you stringing and then you'll go into default territory. And I make the point in the ABCs of self-collection defense, you have got to take control. You've got to set a tone. So I'm always setting a tone. That's what you got to do. You're a victim. I'm a victim. All these law firms are bigger than me. They think, or they used to think they can push me around. That's all right. That's where you get them. So you take control. You go, I'm going to answer my lawsuit on the 15th. Then you do. They're rarely taken aback when a non-represented person, trust me on this, acts out or acts up or acts like they got smarts or something. Act smart. Be smarter. You're going to be smarter than the other side. He's got 100 million cases. He doesn't have time to focus on the facts of yours. Be a good advocate for yourself. We all should be better for ourselves. And the more you seem educated, the more you stick to the facts, they don't want any part of that. They like you to be a victim. You'll get that case settled. So I take that to another level. I say, do what I ask nicely, or I'm going to file a counterclaim. And I did. The next day I did. I wrote in my same email that's up there, the amount of the debt is irrelevant to any analysis if you can't prove the ownership. Like, for example, this was $5,000 debt. They just go, okay. But why? Isn't the amount of debt $5,000 a lot of money? No. When it gets into here, I think it was $17,000. They get weird about that. But it's that, hear me out. They should hear me out, and I hope you do. The amount you owe is irrelevant. If you would buy this, if you would do a mutual with me when it's only $5,000 because you can't prove the ownership, it's the same thing. You still can't prove the ownership. The amount doesn't make your case any better. It actually makes it worse because you're acting like a jerk looking at the amount. And now I'm going to go make attorney fees and costs off you because you didn't want to focus. So I write now, this is where I bring up my big chip. The recent 2023 award of $24 million against PRA by consent order, which means PRA agreed to these draconian restrictions by the CFPB. It also outlined a previous 2015 consent order, which they blew off after being fined for $12 million. So here's where you must focus now. I know this gets to be a little boring, but if you watch my videos all the way through, it all makes sense at the end. I don't know if that's good or bad, but so I focus, and I've highlighted this for you. Hopefully still up there, Cindy. The consent order required original account level documentation, or OALD, which means any documentation that the creditor or creditor's agent, such as a servicer, provided the consumer about the debt. That means the stuff you signed, the stuff you agreed to, whatever it was at the initial origination of the loan must be given to you in this lawsuit. No debt buyer can do that. They may do it tomorrow, but the creditor doesn't sell them all that creditor level stuff. It sells them debts for pennies on the dollar, which screw up their machine. But I think the CFPB knew this. They really had it in for PRA worse than anybody realizes. So the lawsuit against my client's not going to have the OALD, and I point that out. I'm going to educate them, just as I'm asking you to do. Educate them about how educated you are. In this instance, when I'm the attorney that does this 10,000 times a day, I'm educating them about what I got to smack them with. So your lawsuit against my client has none of the creditor level documentation, such as the original contract attached to the PR lawsuit. Again, it's not the amount owed, but the amount of creditor level information PRA must supply now to prove the case. And then, hey, I'm a human being. I like to, from the very day that I became an attorney, something happened in a courtroom, real quickly. I sat in the back with my client, we're just talking, and at the front was this bench full of all well-dressed people. And then at the very front, and you had to open a gate and kind of the bailiff let you in, but they all got to sit there. And I'm in the back with the cheap seats, as Harry Chapin used to call them. And judge comes in, call your first case. And the attorney stands up and he looks at his client, and they were near me, and he did this. Nobody likes this. Nobody likes this. And I go, I'm not going to be that kind of attorney. I'm always going to sit in the back seats, because I've been sitting in the back seats most of my life. So I don't want to be the kind of attorney that just follows a company rule. So I said, and I try to be personal, and human beings have to be human sometimes, all right? On a personal level, I don't agree with the CFPB's ruling. How about that? And their requirements in this order, as neither the FDCPA or federal case law, the Harvey versus Great Seneca case, require that people give this much information, but the rules are the rules, and I am an advocate for my client who will do what is best for her with everything available. You should too. So there's nothing wrong with being a little human. And so I write boldly, your hands are tied by the overreaching mandate of PRA. So I'm coming off as I understand, if you can say in any negotiations, I understand where you're coming from. We're very divisive, people say it, but I don't agree with that. I spent part-time in a red state that I feared that I'd be crushed, and it's the most welcoming place. All they say is, just don't tell us what to do, and we won't tell you what to do, and we get along. So here your hands are tied by the overreaching mandate. I understand where you're coming from. I don't agree with it either. Rules are the rules. And by the way, if there was a major rule that killed my client's case, I'd be hearing about it. So that's what I wrote to them. Fourth, Cindy, the next email. Now I got the named partner coming back to me. Thank you for your email. I spoke with my client once again, and they cannot simply walk away from this type of balance. See how wrongful thinking that is? It's not the balance. You got to prove. You can't even talk about money until you prove you own it. If your client would agree to pay a nominal amount, such as a few $1,000s, see no definition of nominal amount ever being a few $1,000s. I don't care how much you owe $1 million. They just say, pay them nominal amount. It's a lot of money. I'm sure we could resolve this matter. I'm not wound like that. So I send back. Here is my counterclaim. I didn't want to negotiate any further. I set the task. I said, we're going to work this out, or the next day face a counterclaim. I just wrote that yesterday. The counterclaim was also sent to the court. Note, Exhibit 4, which is your group inside ARM's assessment. So their own lobbyist group wrote an opinion about how it sucked for PRA, but they focus, they go, yeah, now we got to do this, we got to do this, got to do this. So I added it as Exhibit, it may be Exhibit 4. I'll add the counterclaim, the actual counterclaim with all the exhibits to my video on this video on collectionstoppersolutions.com. Now, here's the kill shot. I've had to file a counterclaim after trying to work this out with you and presented the above information. So I gave them all that information. That gets a little frustrating, but I make sure I give them the information before I just go charging and seeking attorney fees. Prior to filing the pleading, I will expect FDCPA damages, that's money to my client, for my client, and my attorney fees and costs as a result, and after I gave you your client time to consider everything. 9 times out of 10, when I actually have to go ahead and file the counterclaim I told them I don't want to do, they'll go back, okay, we'll give you the mutual. Freaking bleeping drives me nuts. Because now I got to go to my client and go, I can get you out of $17,000, but I can't settle it because they're not going to pay my attorney fees. And if I don't push them on that, they're not going to trust me the next time I make that. So it's tough. You got to give your client what, if she says, no, Park, I just want to get out of this, I've got to eat my fees. It's part of the business, and I'm always thinking 5 cases ahead. That kind of screws me, not her, but if I do all this and go, I'm not settling unless you pay me that you made me do, and then I do. So I've got a way around that. It's just a pain. I just don't want them to think I'm weak. So my time and costs are not to be discounted after I made such efforts to work this out. So that's what I say. So that's how we do it. This is how we do it. So I filed the answer. Now I'm going to attach my actual answer to this video, and that'll be there in Word template for you to use. Put your facts, whatever you want to put into it. I always talk about pink sticky notes. So when I send something to the court and I really want them to focus, because everybody's got 30 seconds to a minute to focus on your case, I do put the pink sticky note, and I did this for you today. In my answer at page 5 on the template, you'll see I briefly mentioned the $24 million judgment in the answer. This is before all that nonsense. When I sent the answer the first time, we had to go through all that discourse. So it's coming. If it's not like I snuck up on them. It's my business if I do. So that's on page 5 if you want to check that out. But it's just a brief mention of what the court said. So now they didn't listen to me. If they don't listen to you, have a hard rule, all right? You have your counterclaim, all right? So let's briefly look at that so you don't have to listen to me and look at me anymore. So look at page 1 of the counterclaim, right there. Preliminary statement as to no stated claim, violation of the 2023 CFPB versus you're titling everything. And you put your pink sticky note for you and for the court. Next page, Cindy, page 2. Remember the OALD Here it is. It's right on page 2. Shazam. Look at that. Right there, highlighted for the court. And I put a sticky note so the court's like, what is OALD? Because I don't know what so that brings it home. On that same page, see, wrong address and service of summons. Keep it human. Point out exactly what you're doing with big titles, okay? So in this case, as you know, they sued her, then filed it, they served her on the wrong address. Of all the worst people you can send this to, let's say if they send it to her parents, exposing the fact that she's a deadbeat, if you will, that's bad. To your ex-husband who may be needling you and have another reason to yell at you and, hey, you're not good for the kids or whatever, they just did that to her, poor thing. So I make sure the court knows it. I don't just say it, I title it. So I want you to remember that. So page 3, Cindy put it up. And that's, remember the allegations about the bill of sale sucking? By the way, I'm sorry, I shouldn't point to this. You can see I take their documents. So I took the summons and I blanked it out because I respect my client's privacy. I know it's filed on public records. It's just not, you just don't do that. So I put what they put. Here is the address on the summons, Exhibit 2 in defendant's own document showing her real address was in PRA's possession. So I put what they put up, and then I put what they had in their possession. And if you can see, I don't do this. This is their lots of sheets of information. So they had it. I mean, when you say I'm going to do something, you level them. Right now, I haven't heard anything. So we'll see what happens. So I've titled this page, this section, Bill of Sale and Assignment is undated and there's no authority for the signer to sign. So you want to have that there in case the court is so busy, they don't want to look at your nonsense. Go to page 6, Cindy, and there is the reference of the CFPB $24 million judgment against PRA for violating. Now I go deep. I start adding things. And what I added is Exhibit 4. Again, exhibits are important. Say it, support. Say and support. Don't just say it like they do and don't support it. You say and support it. You add your exhibits. Put in the case law of your jurisdiction, and we'll get to something new for you on that. But again, I've got my pink note, and you put the note, you put what you want the court to be alerted to. Put a bright, shiny star or something. Put a gold star if you want. So the court is alerted to this. So then you go to page 7, Cindy, Shazam. And there is the beginning. I've got the word preliminary statement, and I write in bold, PRA has no ownership assignment or chain of title to collect on this debt. It's becoming repetitive now. Sometimes, as I've said in previous years, courts, to remind themselves or other judges that are on this file, they write on their file like it's just a place to put notes. Oh, this is the case that didn't have the assignment signed or dated, blah, blah, blah. I've seen them pick it up. Oh, this is that case where you didn't have the assignment. I'll sit down now. You've made the argument for me. I've got my preliminary sticky note again. So Cindy, go to page 13. Shazam. That's my head Shazam. I was a soccer player, so that's my head Shazam. And there is the green case. What's significant about that, you see, you can barely see green, but you see bold portfolio. That huge green case, it's against PRA. I mean, when it rains, it pours. You've got everything you need now to go crush these guys, right? Now, side note, it's such a good case that someone's filed for an appeal, an en banc appeal, and it stopped this. But can you still use the case? Yes. All the cases that supported the decision of the Virginia Court of Appeals, by the way, it wasn't a podunk court, are allowed to be used as precedent or good law in your favor. So Cindy put up the section on my show notes. By the way, show notes will be attached to the video too. Below, case law covering this case regarding failed or missing assignments or proof. Shazamski. So you can see the second case, Kenny versus who? Portfolio Recovery Associates. Look at all this case law you have. That's one, that's a Texas. Finding no evidence, by the way, win a case in Texas, that's tough. Finding no evidence of ownership of debt where bill of sale offered to prove assignments did not identify which accounts were transferred. Hey, where have you heard that before? And instead identified another document that contains the information that was not a part of the record. So courts do the right thing, okay? And they're out there for you to use. So if this is a Virginia resident or a Texas resident or there's an Ohio has a lot of good assignment cases for folks like us. Look at, put in search term assignment law, Ohio, NCSLT, National Collegiate Student Loan Trust. You get a ton of, it's not just to NCSLT, it'll have all the case law of other cases against PRA and against UHG. UHG is another one, Crown Asset. So use your case law as proof, binding proof. You can use federal or outside case law like Michigan or Wisconsin or whatever state is not in your area. That is helpful to the court, especially if there's nothing contradicting it. So that goes on my affidavit, my affirmative defenses now. So one more, nope, that's it. So that is a copy, I've attached it to the website of the counterclaim where I incorporated the $24 million judgment against PRA. When you're talking with an attorney or a collection attorney trying to settle this, like with those emails I showed you, you can use parts of them if you want. I've got videos specific to that. I've got one video that's how to settle a debt collection case. If I'm right about that, Cindy put it up. How to settle a debt collection case with a collection attorney, put that up. We just did the question and answer with a real attorney. I interviewed a real collection attorney, not a debt collector that travels from debt collection company to. This was a real attorney that knows his stuff. He's been in business as long as I have. That video is up there. All available on the membership website. So the purpose today was to highlight some of the things that you can do with that consent order. It's powerful stuff. It's got a shelf life of about 18 months. If a new president comes along and decides, I don't like the CFPB, it's a government agency. Again, as I've said, the Supreme Court, sorry, I talked too much, I started spitting. The Supreme Court, this term, focused a lot on governmental agencies overreaching, telling cities and states what to do. And they probably look at it as a 14th Amendment thing where, hey, the states have rights too to do their own thing. A federal agency can't come in. Well, this is a federal agency and it's got a lot of flack. It's really good. It does really good things. It balances things. But like anything else, it can be overreaching. I admitted to you on a personal level that I believe this this portfolio consent order is overreaching and well beyond even what the law requires. But PRA signed and said, yep, we agree to this. So please, folks, even though I have personal opinions about it, I like to win. And if it's there to win, I'm going to use it because I'm going to get my kicked by stuff that's against me. They're not going to be personal and go, let's be nice to Parker. No, but I like to be nice. And remember, in your settlement negotiations, try to use the word, I understand. I can understand how you feel. Oh, I can see where that case is coming from. Let the other side know that there is some human being. Empathy is a good approach when you're trying to settle these cases. But you got a hammer right here, man. Hammer them. Now remember, attached to the video is the actual counterclaim. So the actual counterclaim I filed, you can have it, and the exhibits you can use, they're national. Counterclaim template, the actual counterclaim in Word, the counter affidavit. I don't think much about it, but if you're coming to the video for the first time, remember two things. Number one, what do we do? Hello? Everybody tell the new person what we do. Hello? That's right. We use their documents against them. A+ to you. We use their bad or lack of assignment. In this case, they said, hey, the affidavit we've attached, so show and let the court know there is no affidavit. If they've got a bad assignment, which they always do, yes. And in this case also, that Brandy Reardon has signed for Citibank. And check out that signature versus other Brandy Reardon. I can't say what I want to say, but that is an interesting signature and looks very familiar to me. Just check it out. And I also cite the point that she has no authority to sign for Citibank. You got to have that. I have an answer template in Word mentioning the 24 million. My wonderful show notes. You can see my meanderings, but there is some good stuff in there. Remember the emails. I'll attach the emails to and from the law firm, how I settle a case. Remember the videos. There's a video how to settle a case with a debt collector, how to talk to an attorney, and again, the ABCs of self-collection defense. I think it's section 1, telling you to set the tone and to have hard deadlines, and that's how you win the respect. So I hope that's a lot today, but I really was excited about telling you how I actually used the $24 million consent order rather than just talk about it. So that's your video. Thank you. Love, like, and subscribe. We have a new channel coming. It's really tough for me to do, but I'm 62 years old, all right? I'm technically a doctor, believe it or not. I have a doctorate. So I'm going to start a new channel coming up called Life, Love, and the Law. I'll give you more on that. And it's how to handle stuff. How to handle life, love, narcissism, bad relationship, ex-wives, your kids, certain ways you go through life. It came to me, I was meeting with a family, I have young kids, and I shuddered when I saw how they were bringing them up. And then I remembered, I did that too. And I can see from afar that, hey, I should have done better, I should have done this, or I did great. I have 2 very good, smart, self-assured, independent kids. It's luck, and a very good ex-wife. So I'm starting a channel, how to give you tips, take it or leave it. And hopefully you can take it. You just can't take this face. So thank you very much. GettyWeb.com, GEDIWEB.com. Get ready with Getty. And thank you. Have a great day. Bye now.